everyone. I hope everyone is safe and doing well. Now, in the last two episodes, we discussed about the meaning of a due diligence exercise. Why is it undertaken? What's the importance of this due diligence exercise? On whose behest is a due diligence exercise undertaken? And in particular, in the last episode, we discussed about the reason for incorporating a introduction and scope chapter in a due diligence report and its importance. Now, in this episode, we'll be discussing about the various chapters which are incorporated typically in a due diligence report, and we'll also be discussing about the first chapter in a due diligence report, which is the corporate chapter. Now, typically in any legal due diligence report, these are the chapters which are incorporated: corporate chapter, material contracts chapter, real estate chapter, indebtedness chapter, consents and approval chapter, human resource chapter, insurance chapter, disputes chapter, information technology and intellectual property chapter, and in some cases the anti-bribery chapter, depending upon the requirements of the client. So today we'll be discussing about the first chapter in any legal due diligence report, which is the corporate chapter. So I may not be in a position to deal with each and every document which typically one must review for a legal due diligence report when one is drafting a corporate chapter, but I'll try my best to at least take you through the key documents which one has to review or keep in mind while drafting a corporate chapter. Now, the first document which comes in my mind would be the Articles of Association and the Memorandum of Association, basically the charter documents of any company. So, as you all know, AOA is like the constitution of a company. So, when you are reviewing AOA, you have to keep two things in mind. The first point being whether the AOA is as per the format prescribed under the new act, and number two, if at all the AOA has any share transfer restriction or any type of restrictions on the issuance of the shares depending upon the nature of transaction. Like for example, if the proposed transaction involves transfer of shares from one shareholder to the investor. So, in case the AOA has any share transfer restrictions, then that must be highlighted in your report. Or let's say if there is a proposed issuance going to happen, basically if the proposed transaction involves issuance of shares, and if there is a specific preemptive right present in the AOA, it could be flowing from a shareholders agreement, then in that case that should be highlighted in your report. Now, coming to a memorandum of association. So, these 2-3 points which you have to keep in mind while reviewing a memorandum of association. Number one, again, if it's as per the format prescribed under the Companies Act 2013. Number two, since the memorandum of association captures the key objects or the main objects for which the company is incorporated, you have to ensure that the key actually the operations of the company are going hand in hand with the objects stated in the MOA. So basically, let's say there are 20 objects stated in the MOA of the company, and the company is doing completely something totally different. So this is a key red flag which should be highlighted. But in all probabilities, you have to be very careful and read each main object very carefully. Ideally, somewhere or the other, the operations of the company are in one way or the other linked with the objects which are stated in the MOA. So, apart from these 2 points, the third point which you have to keep in mind when you are reviewing the memorandum of association would be the authorized share capital of the company and details pertaining to the share capital of the company. So, let's say you have been given details about the authorized and paid up share capital of the company, and they are not matching with the MOA. Then in that case there is some disconnect. Like in all probabilities, the MOA which you have been provided could be old one. So in that case you will have to requisition for the latest copy of the memorandum of association. So another important document which you have to review very carefully when you are dealing with the corporate chapter would be the annual report of the company, which would consist of the board report, the notings of the auditors in form of the auditor's report, and even the financials of the company. And when you're reviewing the annual report, you have to be very careful. Even though as lawyers, someone may say that I'm a lawyer, how am I supposed to review the financials? But I firmly believe that every lawyer should have some basic understanding of the financial statements of a company. And always don't read the annual report in isolation, or don't just restrict yourself to whatever is there in the financial statement and just blindly document it in the annual report. And annual report is a document which I believe that everyone whoever who is working on that due diligence report should have a look at, and it should not be restricted to someone who's working on the corporate chapter. The reason being is that there could be a situation wherein there are certain specific notes to a financial statement which are mentioned, which would be relevant to the other chapters also. A small example I'll give you, that there could be a situation wherein it could be mentioned, like let's say the company is into hotel business. There could be a situation wherein the company owns a particular hotel, and in one of the notes to the financial statements it's specified that the company has received some specific show cause notice with respect to the building plan not being in order, or let's say as per any specific legislation some license is not in place. So this in some form or the other there could be a situation wherein some note to the financial statement could capture all this, or let's say some litigation pending against the company for which there could be a liability pending against the company. There could be a fine or penalty which is captured in the notes to financial statements. So for such matters, it is very important that someone who's someone who's drafting the consents chapter, someone who's drafting the litigation chapter must have a look at the annual report and must document such findings from the annual report into their respective chapters. And at the same time, someone who's drafting the corporate chapter must also give a reference to such findings in the corporate chapter and linking it with the concerned chapter. You can just add a line saying that for details kindly refer to the consents and approval chapter or the litigation chapter for that matter. And also another additional point which I would want to add, and this applies not just to the financial statement but to not just to the annual report but to any document which you will receive as part of a due diligence exercise, is that if any document is dated as of a particular date and there's a time lag between that date and the date when you are reviewing the documentation, there is a high possibility that the situation would have changed. So I'm just giving a very simple example. Let's say you are working on a DD and you are reviewing the annual report of a company which is dated as of 31st March 2020, and now you are diligencing the documents in the last week of August 2020, and there is a note in the financial statements mentioning about any specific penalty or any fine against the company or any dispute against the company. So it's very important to requisition or ask the company whether that specific dispute is pending or whether that penalty has been paid off, rather as opposed to just blindly relying on the annual report and the financials and documenting it in the your specific chapter. So it's always good, or as a matter of practice, to ensure that whatever information you are including in your report is updated, and you are not just documenting whatever you found from the annual report if there is a situation wherein there can be a time lag. Obviously, if the financials are audited with respect to information with respect to the specific financials or the liabilities, there could be a situation wherein the company has not provided you any adequate information post 31st March 2020, then obviously in that case you will rely on the information which has been provided or which has been given in the financial statement. But from your side, it's advisable to seek clarity from the company with respect to any particular updates which you think can be there by virtue of the fact that the financials are dated as of a particular date. Now, any sort of adverse remarks which are mentioned in the financial statements of a company by the auditor, specifically in their auditor report, must be highlighted. Like for example, if the auditor has mentioned that the company doesn't have adequate financial control, that is a red flag and must be highlighted. Let's say the auditor has mentioned that the net worth of the company has been eroded. So this is something which must be documented. And if you're a lawyer, I firmly believe that a basic understanding of the financial statement and whatever is documented in a financial statement and the annual report is very important. When you're working on a due diligence report, it's very important to have a clear understanding of the current shareholding pattern of the company. There could be a situation wherein the company has provided you the latest shareholding pattern of the company as of a particular date, or there could be a situation wherein the company has not provided you the latest shareholding pattern, and you only have the only way possible wherein you can check the shareholding of the company as of a particular date then would be by checking the annual return of the company, because the shareholding pattern or the list of shareholders of the company is an annexure to the annual return of the company. Even in that case, you'll have to seek a confirmation from the company and check with them whether there has been any specific change in the shareholding pattern of the company since the date of filing of the annexure to the annual return. Or for that matter, even if you have a copy of the annual return with the annexure of the list of shareholders, and if there is a time lag between, like let's say the annual return obviously would be dated as of 31st March of a particular year. So the annual return is dated as of 31st March 2020, and it has the list of shareholders, and you have even been provided with a list of shareholders by the company which is dated as of let's say 25th of August 2020. And if you are doing a diligence, then it is like ideally what you should do is that you should not totally rely on the shareholding pattern provided by the company. It's totally up to you, but you should also map and check that how, like, and if there's a difference between the shareholding pattern annexed to the annual return and the annual and the shareholding which has been provided to you, if they don't totally match, then you, by way of the form filings which has been made by the company, like let's say you'll have to check whether there has been any rights issue, any preferential issue, or let's say like you'll have to understand the reason why there has been a change in shareholding pattern. You'll have to map with the form filings. You'll have to have a look at past 3 filings. You have to check the share transfer forms and ensure from your side that the shareholding pattern which has been provided is the latest shareholding pattern of the company. While drafting the corporate chapter and while reviewing the documents for a corporate chapter, any type of agreements which are inter se governing the rights and obligations, liabilities of the shareholders, or if they are like informal, like it could be a shareholders agreement, then such agreements should ideally be reviewed very carefully. And if there are any transfer restrictions, or if there are any change in control provisions, or in particular if there are any preemptive rights, so depending upon the nature of proposed transaction, you have to review the agreements in light of the proposed structure of the transaction and document your findings and give your recommendations as well. And this is not just limited to a shareholders agreement. In case there is any joint venture agreements which the company has executed, which are in place, which have not been terminated, these agreements also must be reviewed very carefully. Every Indian company, be it a private company, be it a public company, be it a listed company, has to make a lot of filings with several authorities. If it's a listed company, then with the SEBI or the stock exchanges. If it's just a private company or just a public company, then with the Ministry of Corporate Affairs or the RBI if applicable. Obviously, for the purpose of this video, it's not possible to discuss all sort of form filings and how we review such form filings. But at the same time, I would want to stress on the fact that if it's any form filing with any specific government authority, specifically RBI or the Securities and Exchange Board of India, then such form filings must carefully be reviewed, specifically if there is any specific time period specified for making such form filing. To give a very simple example, if the company has received FDI, or if the company has overseas direct investment, then in that case form filings like APR, annual performance report, or FLA, which is return on foreign liabilities and assets, these form filings, or form ODI for that matter, these form filings have to be in particular kept in mind. Also, if for that matter, if the company has non-resident shareholders, and if there has been any transfer of shares from a non-resident shareholder to a resident shareholder for that matter, then form filing like FCTRS should be reviewed. Or if you're not reviewing the form particularly, then at least the acknowledgement received from the RBI, at least which indicates that the form filings have been made in place, they are in order, and they have been made within the time period specified under the specific FEMA regulations. That should be checked, and that's the same logic would apply to a situation wherein one of the shareholders is a non-resident entity, and the shares were issued to such non-resident entity, and in that case form FCGPR must be seen, that it has to be ensured that the company, because the obligation of filing this form is on the company. So this is something which has to be kept in mind. And at the same time, if it's a listed company, then there could be form filings which are required, or any type of disclosures which could be required on the part of the listed company, which it has to disclose to the stock exchange, or for that matter to SEBI itself. Then these form filings and disclosures, at least in the particular time period of your diligence, that these filings must be kept into mind when you are working on the corporate chapter. For the corporate chapter, another important document which one must review, if at all there is any, would be the ESOP plan. So if the company has adopted any particular ESOP plan and has granted stock options to the employees, then you should, number one, review the specific plan very carefully and ensure that it is in compliance with the Act and the ESOP rules pertaining to ESOP framed thereunder. And at the same time, you should even you should go a step ahead and even review the grant letters by virtue of which the stock options have been granted to the employees. And by way of your review, you should in form of a table, if it's a red flag report also, like depending upon the needs of your client or for your own reference, at least you should document that how many options have been granted, how many stock options have vested, how many stock options are unvested, and how many stock options have been have exercised or have lapsed. So this is something very important, which I felt one should always keep in mind when one is reviewing any ESOP plan and grant letters, and ideally document it in the corporate chapter. Then at the same time, if there are any corporate actions undertaken by the company in the review period, we discussed the concept of review period in the last video, then any sort of corporate actions, be it merger, amalgamation, or capital reductions, bonus issuance, rights issuance, any sort of allotment, and the concerned form filings, one must always carefully check and ensure that there have been no non-compliances. And in case some form filings have not been provided by the company in your data room, or by way of if you are doing a physical DD, then if you are not able to locate those form filings or a copy of those form filings, then in that case you should requisition such form filings and from the company. Then I would also mention that there are some statutory registers which every company has to maintain, like for example, register of members, register of KMPs, if the company has issued ESOPs, then register of ESOPs, if the company has debentures, then register of debentures. So these compulsory or register of charges, register of loans and guarantees, RPTs. So these statutory registers a company is required to maintain. So this is something also which you have to review, not just check whether the company has those registers or not. You have to ensure that whatever has been recorded in the register is in order, or if it is specified in the Act or the rules that the register has to be in XYZ format or in form XYZ, then you have to ensure that the registers are updated to meet the compliance requirements of the Act. So viewers, today we discussed about the corporate chapter in detail. I may have missed some specific requirements which you have to review, but I have tried, given the paucity of time, it's not actually possible and feasible to totally discuss each and every documents which you have to review for the purposes of corporate chapter, but I have tried my best to at least cover the basic or the key documentation which you have to review and how you have to review. In the next episode, we will be dealing with the other chapters in a legal due diligence report. Thank you.